New Jersey's criminal justice system is undergoing a major reform. Based on a voter-approved constitutional amendment, it includes reforms to the bail system and a new speedy trial law which sets time frames for criminal cases.
As for bail, the problem historically has been twofold: that too many poor defendants who pose a minimal risk of danger, minimal risk of flight, sit in jail for too long pre-trial because they can't make even modest amounts of bail. And in the course of doing so, many of them lose access to families, to medication, may lose their jobs. Meanwhile, defendants who are accused of serious violent crimes who pose a significant risk of danger in flight have been eligible for bail under our Constitution, and if they have access to clean money, are able to make bail and be released, which presents a real public safety issue for witnesses, for the community at large.
Under the new system, once a defendant is arrested, police will contact a judge who will decide if the case proceeds as a summons or on a warrant. If it is a summons, the defendant will be released. If it is decided the case moves forward on a warrant, the defendant will appear before a judge within 48 hours to determine the conditions of release. Those conditions could range from a phone call reminding them to appear in court to house arrest or electronic monitoring. Chief Justice Stuart Rabner says the system will
move away from a system that relies heavily on imposing money bail to one that relies instead on objective, risk-based measures to evaluate the level of risk that each individual defendant presents and determine the appropriate conditions for release, to be supervised by pretrial services officers. The other end of the spectrum, defendants who pose a significant risk of danger in flight can be held without bail in line with the governor's original proposal on pretrial detention and the constitutional amendment. And the new law, as you know, provides for a Speedy Trial Act that has finite periods of time for the period from arrest until indictment and from indictment until trial, with appropriate exclusions for a number of different proceedings.
This change will create a new pretrial services division whose officers will conduct an estimated 70,000 risk assessments per year. Those risk assessments help judges and the court decide how to set conditions of release for criminal defendants.
The approach that we are embarking on exists in other places with success. In Kentucky, for example, more defendants are being detained who present a high risk, and more defendants overall are being released pre-trial. Yet there's been no increase in the rate of failures to appear, and the arrest rate for defendants who are released pre-trial on supervision has dropped.
Pilot programs in Camden, Morris, Sussex, and Passaic counties begin March 2016. The new law takes effect statewide January 1, 2017, and the judiciary has been working on systems and procedures to make sure it happens smoothly and on time.
And that when that happens, our state will have a better and a fairer system of criminal justice that we will be proud of.